Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. So today's topic is going to be about, can you disinherit your spouse in your estate plan? But before we dive into that topic, if you have any questions pertaining to estate planning or probate and you want to schedule a free strategy session over the phone with me, head on over to njestateattorney.com to schedule a day and time that works best for you. So this was actually a question that I responded to on a forum for attorneys that nationwide, and I thought, why not bring this to you? And there's a lot that goes into this, but I want to break this down into multiple videos because in one video it would be so much information your head would spin. Even just reviewing the statutes and everything, even though I remember all of it, my head started to spin. So if my head's spinning, this would be like going on a tilt-a-whirl. So to answer the question, in your estate plan, if you're creating a will, you can put in there, I don't want to leave my spouse anything. Okay, you don't have to put your spouse on as a beneficiary designation. However, when you pass, if your spouse gets nothing, or if more than 2/3 of your estate goes to other people, your spouse has the right under New Jersey law to file a complaint in the surrogate's court within 6 months of the personal representative being appointed to claim what is known as the elective share. What is this elective share? The elective share is basically 1/3 of what we would call augmented estate that the decedent leaves. Now, how do we calculate the augmented estate? This basically, we take the funeral costs out, we take administration costs out of the estate, and after paying off the debts of the estate, we're left with what is known as the augmented estate. That remainder would get divided by 3, and 1/3 of that goes to the surviving spouse. So in this very simple scenario, and I'll even give you an easier one. For example, let's say I have an estate worth $1 million. I don't leave anything to my wife. All my beneficiary designations were not to her. I pass. She gets 0. My wife, my will gets probated by my executor. She files a complaint with the surrogate's court saying, I'm invoking my right to the elective share. The court would come in, we do this calculation. What were David's funeral costs? What were the administration costs? And what were the costs of the creditors? Let's say before we divide, we're left with $600,000. There was $400,000 of costs. We divide that, she would get $200,000. And the other $400,000 would be sent over to everybody else that it's directed towards. I will break this down further. There is more ways. This is really just a down and dirty, as simplified as we can get version of you cannot disinherit your spouse. At the end of the day, if you do, your spouse is going to end up with 1/3 of it if they start going, if they file that complaint that they want to invoke their right to that elective share. So, to summarize, you can't disinherit your spouse. They'll still end up with 1/3 of something. So, instead of trying to do it this way, give them what's rightfully theirs. Hope you found this video informative. If you did, please head over there, hit that like button, head on over to YouTube, where we are posting content daily. Also, head on over to TikTok, Instagram, at NJ Estate Attorney. We're posting up quick videos there. We also have our podcast, New Jersey Estate Planning Daily. If you want to hear this in the car, you want to hear this when you're exercising, please go listen to us over there. If you have any questions pertaining to this topic or any other topic in estate planning or probate, and you want to schedule a free strategy session over the phone with me, head on over to njestateattorney.com to schedule a day and time that works best for you. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.